Hey, Tennessee, if you're a freedom, liberty-loving American, you need to really pay attention to what I'm going to say in this video. And what I'm teaching here, what I'm educating on, is how our government has unlawfully altered its form of government. And the result of this unlawful alteration of our form of government is many acts of pretended corrupt legislation, absolutely no justice in our courts, and judges are literally held above the law. So let me go in and explain. This is profound. Like, every dissatisfaction that you have with government, this is the root cause of it, that our government has altered its form. And so if it comes down to you're disgusted that citizens can't speak in county meetings, or you're disgusted that citizens can't speak in school board meetings, or that our legislators ignore you, or that you've been subjected to corrupt court proceedings, whatever it is, this is the root cause that I'm going to go into right now. So I'm going to first read, this is the Tennessee Constitution preamble. And this is important for understanding this. In the preamble, the last paragraph, it says, we the delegates and representatives, in pursuance of said act of assembly, have ordained and established the following constitution and form of government for this state, which we recommend to the people for their ratification. So the key word we're looking at here is form of government. And we all know that this Constitution, it establishes a legislative branch with two houses, executive branch, the governor and his agencies, and the judicial branch. We all know that, but there's many aspects to the form of government that is established and ordained and ratified by the people in here. And part of that form of government is in Article 6, Section 7, that establishes the judiciary. And in Section 7, it says, the judges of the Supreme or Inferior Court shall at stated times receive a compensation for their services to be ascertained by law, which shall not be increased or diminished during the time for which they are elected. And here's the important part. They shall not be allowed any fees or perquisites of office, nor hold any other office of trust or profit under this state or the United States. So judges, now the reason that they did this, the English Whigs, that political party, greatly influenced the framers of our state and federal constitutions. And the Whigs were constantly complaining that plural office holding, those individuals holding two offices, it always leads to corruption. And so they put in our Constitution, it's called the incompatibility clause, that if you have one office, you're incompatible with any other office of trust or profit under this state. So let's go look and see what we have. This is a print of the website from the Board of Judicial Conduct. And on their homepage, it says about the Board of Judicial Conduct. The regulation of judicial conduct is critical to preserving the integrity of the judiciary and enhancing public confidence in the judicial system. The Board of Judicial Conduct was created by the legislature and is intended to provide an orderly and efficient method for inquiring into the physical, mental, and moral fitness of judges serving in the judicial branch of government, the judge's manner of performance of duty, and the judge's commission of any act that reflects unfavorably upon the judiciary or brings the judiciary into disrepute, or that may adversely affect the administration of justice. So the purpose of this agency, it was statutorily created by the General Assembly, and the agency is staffed. There's 8 judges in the Tennessee Board of Judicial Conduct. And the Constitution said expressly, judges are prohibited from holding any other office of trust or profit under this state or the United States. But we've got 8 judges in the Tennessee Board of Judicial Conduct holding expressly prohibited offices. And when we've got judges, overseeing judges in the Tennessee Board of Judicial Conduct, what we have is the fox watching the hen house. And in the Tennessee Constitution, Article 5, the House has the sole power of impeachment. And in Article 6, Section 6, judges may be removed by concurrent vote of both houses. Judicial oversight is legislative power. It is the check of one branch over the other. And in 1971, when they created this unconstitutional agency, the Board of Judicial Conduct, the legislature surrendered their power to the judiciary, and the judiciary usurped legislative power and took that power for themselves. And since that agency was created, they have not once recommended the removal or impeachment of a single judge. And the new chair of that agency, Judge Gay, General Sessions Judge out of Sumner County, he was asked, well, what if you got a judge that commits crimes? And Judge Gay said, well, typically they just resign, and there's nothing we can do at that point. And so we have judges like Judge Davenport, who was wrongfully incarcerating children, and she just resigned. Oh, sorry. I guess I'll just leave my office now, and I don't have to suffer for any crimes. Meanwhile, the state, I assume it's the state, paid out I think a couple $100,000 in restitution to some of those families for wrongfully incarcerating children. We've got Judge Woodrow Adams indicted on 3 counts of child rape. You've got Casey Moreland, who planted drugs he bribed a police officer to plant drugs in the trunk of a car of a witness against him, to try to cover up his crimes. So let's talk about what is an office of trust. And I want to go over this because Senator Kerry Roberts wrote in an email, and he said, well, we understand Mr. Gentry's position, but we have a lot of legislators and legal experts who say that the Board of Judicial Conduct is not an office of trust. Tell me who these liars are, because I want to debate them. Tell me who these legislators are that don't agree with me. Tell me who these legal experts are, because I will crush them in a debate. The Board of Judicial Conduct is an expressly prohibited office of trust. So let's go look. What is an office of trust? So this is Black's Law Dictionary that I'm looking at. It says an office, a right and correspondent duty to exercise a public trust. And it goes on, it says, what's a public office? And it says the right, authority, and duty conferred by law. And remember, the Board of Judicial Conduct was created by the General Assembly, so they're conferred by law. An individual is vested with some portion of the sovereign function of the government for the benefit of the public. And that's just what we read. The description and the purpose of the Board of Judicial Conduct is to preserve the public confidence in our corrupt judiciary. In other words, preserve false public trust in a bunch of attorneys in black robes that are conspiring and aiding and abetting rights violations and extorting the people under color of law. So let's go look. This is a book. It's called A Treatise on the Law of Public Offices and Officers. And how I came across this book, when I first found this unlawful alteration of our form of government, I was like, well, what is an office of trust? I was just like you. I didn't know. I had to go look this stuff up too. So I just put in Google, and I found a brief written by the George Bush Legal Counsel. And in that legal counsel, or in that brief, they were talking about what is an office of trust. And they cited that the White House Chief Legal Counsel cited this book in there. And this was written in 1890 about what are offices of trust. And in section 1, it says, a public office is the right, authority, and duty created and conferred by law, which for a given period, an individual is invested with some portion of the sovereign function of government to be exercised by him for the benefit of the public. Now that's almost exactly, the same definition of an office of trust that we read in Black's Law Dictionary. It goes on and it specifically defines an office of trust. And it says an office whose duties and functions require the exercise of discretion, judgment, experience, and skill is an office of trust. And it is not necessary that the officer should have the handling of public money or property or the care and oversight of some pecuniary interest of the government. So when you look at what is the purpose of the Tennessee Code Commission or the Tennessee Board of Judicial Conduct, it is exactly a prohibited office of trust. It is an unlawful alteration of our form of government, and it's the root of all corruption in this state. Now let's take and look at okay, so you've got bad legislation coming out of the General Assembly, and you want to go sue for that bad legislation, and you want to say that it's unconstitutional, or you want to sue a state official, and you're going to a court of law or a court of equity to do that. Now, if that judge makes false application of law, denies you due process, makes ridiculous rulings, you go to your representative, and he says, oh, well, you need to go to the Board of Judicial Conduct. And the Board of Judicial Conduct dismisses 100% of complaints filed by non-legal professionals based on their own annual reports that they prepared. They don't do anything to provide oversight of the judiciary. And as Judge Gay said, well, if they resign, there's nothing that we can do. Now, here's the other part of this problem with judges holding prohibited offices. So the Tennessee Constitution, again, it says no judge shall hold any other office of trust or profit under this state or the United States. Well, here we got, this is the Tennessee Code Commission, picture out their website. This is the Tennessee Code Commission. And as members of the Code Commission is that, get this is the Chief Justice of the Tennessee Supreme Court and Justice Bivens. We have two justices from the Tennessee Supreme Court who are incompetent, and they are holding expressly prohibited second offices of trust. So what's the purpose of this Tennessee Code Commission? So I'm reading from their website, the Tennessee Code Commission directs the publication, sale, and distribution of the official compilation of statutes, codes, and laws of the state. So they compile the laws of the state. That's their stated purpose on there. Let's go look at what they really do in there. This is in Tennessee Code, Chapter 1, Section 1, or Title 1, Chapter 1, Section 106. It says the Tennessee Code Commission has full power and authority on behalf of the state of Tennessee to perform all acts and to negotiate into contracts for the successful publication of Tennessee Code annotated. Power of the state. That's the definition. The sovereign power of the state is an office of trust. And here we have two justices from the Tennessee Supreme Court holding expressly prohibited offices. This is in TCA 114. The commission, now get this, the commission may prepare and submit to succeeding sessions of the General Assembly its recommendations for revision in substance. Okay, drop just for a second. So they can make recommendations to the General Assembly for change in the substance and form of legislation or the repeal, and submit bills for the accomplishment of such proposed revision. All right, now think about this, people. Tennessee Constitution, Article 2, there shall be three distinct departments, legislative, judicial, and executive. Section 2, no person belonging to one branch shall exercise powers properly belonging to either of the other branches. But here you got two justices out of the Supreme Court statutorily authorized to submit bills for the accomplishment of revision, repeal, or amendment. You've got justices legislating. It is wrong. It is a violation of our Tennessee Constitution. It is an unlawful alteration of our form of government. And it is also the root of all corruption that is going on in this state. Let's go on and look at this Code Commission a little bit more. This is in Section 108, Substantive Change in Text Prohibited. So it's, well, that's the title of it. Oh, but there's these parts where they can change things. So the Chief Justice and another, Justice Bivens, can literally alter the acts of Congress when they put it into our law. And so it says they can't change anything except, okay, here's the except. They're authorized to rearrange, regroup, renumber the titles, chapters, and sections. Maybe that's okay. They can change the wording and prepare new headings and symbols, and to substitute the proper section reference to the terms of this act or whatever. That's probably not too bad. They can correct the misspelling or typographical errors. Now let's talk about typographical errors. The Tennessee General Assembly changed one letter in the Tennessee Constitution in the last phrase of Article 1, Section 23. They changed the word or to of. They changed one letter, they call it a typographical error, and it stripped citizens of the right to orally address our legislative houses. And so I don't want to give justices who are not legislators, who are expressly prohibited from holding second offices, who are expressly prohibited from exercising powers belonging to either of the other branches, I don't want to give them power to edit the public acts of the General Assembly. It goes on and it says they can, now get this part, the Code Commission can omit enacting clauses, repealing clauses, severability clauses, conditional clauses, preambles. They can omit the preamble from Tennessee Code when the General Assembly makes an act of the General Assembly. They sometimes write a preamble to it, and they can omit the preamble that declares the legislative intent. They can literally take that out. And when you take out the legislative intent, and then you're forcing people to go back and find the video back on the General Assembly website where they talked about why are we creating this law. When you take out the legislative intent, and this Code Commission is statutorily authorized to do that, they can effectively transform the law into anything that they want. Now, when we've got a Chief Justice for the Tennessee Supreme Court, along with Justice Bivens, how possibly do we challenge repugnant legislation that's coming out of the General Assembly? Because by these guys compiling, editing, and annotating that legislation, they've effectively waved their hand over it already. So they cannot render, and also they can prepare and present bills. They can prepare and present legislation as justices of the Tennessee Supreme Court. Now, how possibly, if they're the ones that maybe made the recommendation for the substantive change, or they're the ones that wrote the bill on the change, how possibly can you have a fair and impartial court to determine the constitutionality of the statute? And so these justices, being incompetent, not knowing the Tennessee Constitution or corrupt, and holding expressly prohibited offices, they have rendered themselves incompetent of performing the basic function of their office to determine the constitutionality of the laws of this state. So this is an incredible problem. Anything where you're challenging government, you have to have fair courts to go to if you're going to have justice. But you don't have fair courts because you don't have judicial accountability. And you don't have judicial accountability because you got 8 judges in the Board of Judicial Conduct overseeing their buddy friends. Now, this is an unlawful alteration of our form of government, and it is the breakdown of everything that is wrong going on in this state. Bad legislation, corruption in the judiciary, agencies like CPS wrongfully taking children under color of law. There is an incredible list of different methods of extortion that the courts use to transfer money from litigants to the attorneys. It is all incredibly broken. And there is nobody in this state that has the courage and the knowledge or the integrity to stand up and say, hey, does anybody else see something wrong here? Can anybody else not read the Constitution? I can read it quite well, and it is appalling to me, and I am disgusted that our legislators have created these unconstitutional expressly prohibited offices, and I have brought it to their attention. I have spoken down to the General Assembly, and they say, we don't care. We're going to do what we want. And the reason they can is because the people are weak, and they won't take the time to stand up against these bad actors in government acting grossly and blatantly in violation of the Tennessee Constitution. So I'll tell you what, if the people don't want to do their job, put me in office and I'll do the job for you. I will literally shut down the General Assembly until they once again begin acting in compliance with the Constitution of this state. Put me in office and we will reform government and restore the rights of the people. So thank you for taking time with me today. This is an incredible problem, and I want to reiterate and keep hounding on this because it's an unlawful alteration of our form of government at the root of all corruption in this state. So God bless, Godspeed to us all, and in God we trust. John Gentry for Governor 2022. Thanks.